All right, welcome to Law and Crime Network's Law and Crime Report. I am your host, Bob Bianchi. Just 8 days ago, rocking the nation, rocking our democracy, a raid, an insurrection in the Capitol, the seat of democracy, loved and respected around the world. And you all know the story about what happened there. And the consequences of it now are the Biden inauguration has up to close, we're being told, 20,000 National Guard troops that will be there in addition to other law enforcement assets. It is an unbelievable mark with consequences that will go on both domestically and internationally for many years. Let me bring in my guest very quickly so we can get started. We have Michelle Heyman-Kantor out of New York, a former ADA at a Queens County District Attorney's Office with over 10 years experience handling many felony trials, white-collar crimes, sex crimes, and domestic violence cases. And interesting, she was a broadcast news writer. And we have Bob Hille, a law and crime analyst, always here on the Law and Crime Network, and a former New Jersey Morris County friend of mine. We practice in the same area. He focuses in insurance and healthcare law, state and federal white-collar investigations. He's a certified Supreme Court civil trial attorney, a very, very coveted distinction to get here in the state of New Jersey, the past president of the New Jersey State Bar Association. Guys, let's just jump right into this. We are being told that the Secret Service is in charge of this investigation. They have cordoned off and blocked with fences and barricades and barriers, blocks and blocks around where the vice president's residence is, where the White House is, and the Capitol, as well as where the inauguration is to take place. Bob, let me go to you first. I mean, I know there's two sides and people feel one way or the other, but there is absolutely no justification of what went on here. Shocking to me was the fact that we could actually have this happen with literally no police response, no law enforcement response. So what are your thoughts, Bob, about this whole thing and what impact this is going to have on how people view us, even bad actors internationally, as we now have to take our law enforcement assets and concentrate on domestic terrorism, which takes away our ability to investigate international terrorism? Bob, terrible situation. What do you think?
Well, I think the first thing, obviously, those who were in charge of keeping security, that day on January 6th, misjudged the size of the crowds and misjudged how the crowd would respond. They clearly weren't ready for the type of activity that occurred. In terms of how we're viewed outside our borders, I think a lot of that's going to be determined by how we respond on Inauguration Day. And as you talked about, Bob, security's been beefed up. Intelligence is being monitored. The Secret Service has taken over jurisdiction and is coordinating National Guard forces of about 20,000 U.S. Capitol Police, the Park Police, Washington Metropolitan Police Department. So this time you have everybody working together. And the key, I think, to success here is they're trying to keep the crowds further away. They're trying to create a configuration that's going to keep crowds from getting large. And then they're going to have the forces in place to make sure that they can minimize any harm that those crowds might try and do.
Okay, Michelle, my spidey instinct as a former prosecutor are in the red here right now. There is, I think, going to be a lot of information that's going to come out that there were people that were involved in law enforcement, potentially the Capitol Police themselves, and in the military that were part of all this. So that's going to be a big thing that we're going to have to cover with respect to that. And moreover, from this point going forward, what do we do to, as far as use of force is concerned? I'm just curious. If people breach a perimeter at this inauguration, I'm not even sure if it's lawful, so I don't know the answer, but I'll throw it to you. Is shoot to kill, is that an appropriate response at this point? Because you cannot let people get to the new president by any way, shape, or means. And don't get me wrong, folks, before people start getting agitated, I'm not suggesting that people just be shot and killed, but unfortunately, good people that are protesting are mixed in with these elements that are bad, and innocent people are going to get hurt. What do you think is going to happen with the use of force policies here?
Well, I think even in just the first clip that you showed, it was really poignant to see that the police officer was chased back in the Capitol by a mob itself. So that is the first thing that has to change. And I think it's going to, because as you mentioned, with 20,000 National Guard being brought in, plus thousands of other police officers. They're already on the right road to getting this taken care of. And they're going to be armed, which I think is a difference from before. And you juxtapose that with 8,000 troops for Trump or 6,000 for Obama, you can already see a staggering presence and a difference from what happened last week. Shoot to kill would obviously be everyone's last choice, but I think they're going to be armed right now and they're going to be prepared in a much more different way than they were for the Capitol siege.
Yeah, the problem to those innocent people, and I can't emphasize this enough as a public service announcement, if you are a protester, that's what our country is about. Stay away, because infiltrated within these groups are people that are there dying to destroy this government. Not Democrats, not Republicans. They are just anti-government. You don't want to be anywhere near them if something bad happens. Let's switch gears a little bit to talk about some of the folks that are involved in this. Everybody will remember the famous picture of the individual that was in there with the Camp Auschwitz shirt and had that German logo, which is a very offensive. Work brings freedom. Robert Keith Packer has been arrested. Again, another incredible thing. Let's just throw it to the U.S. Attorney as they're talking about this.
The men and women of the FBI will leave no stone unturned in this investigation. Since these events, the FBI has worked hand in hand with the United States Attorney's Office and our law enforcement partners here in D.C. and across the country to arrest and charge multiple individuals who took part in the destruction. In 6 days, we have opened over 160 case files, and that's just the tip of the iceberg. The significance of this investigation is not lost on us. This is a 24/7, full-bore, extensive operation into what happened that day. We cannot do our job without the help of the American people. Since our call for tips, videos, and pictures, we have received more than 100,000 pieces of digital media, which is absolutely fantastic. And we are scouring every one for investigative and intelligence leads.
One of the beautiful things about this whole thing, as far as an investigative standpoint, is this is a group that typically believes that their quote unquote freedoms don't require that they wear masks. Thanks for that, as far as law enforcement is concerned, and then posted their stuff on social media. Double thanks for that. I don't know if you get credit for stupidity with regard to that or what have you, but Bob, let me go back. I mean, it's not just this guy from Auschwitz, the Auschwitz shirt that's been arrested over 12 times. We have people like that, the kid that you saw that's from New Jersey, 28 years old, where a woman was shot and killed by Capitol Police as she tried to enter into the chamber, who had blood on his hand. Well, he's been arrested. William Pepe, 31, who is a New York MTA worker. He's been arrested. 2 Rocky Mountain police officers, just amazing. They've been arrested, and there's indications that there are more police that may be involved with that. And I can go on and on with the list of people, including an elected state representative who has been arrested as well. Bob, what do you think? Like, what is the dynamic here? Have they been unleashed? Has crazy been unleashed? And now they're taking advantage of the environment we're in politically? And is the genie out of the bottle, Bob?
Well, it could be. When that wave crashes and loses its energy, we don't know. But, as the FBI director talked about earlier, there's an ongoing investigation here. Now, most of the people, this is not about First Amendment. They're not being arrested because they even had an Auschwitz hoodie. They're being arrested because they disregarded directives. They had no authorization to be where they were. They had no entitlement to cause damage, to cause physical harm. And so once they passed those barriers, they stopped exercising their First Amendment rights and became criminals. Now, what's interesting is most of the initial crimes that these people have been charged with have all been sort of criminal trespassing charges, destruction of property charges, and disorderly persons. But as they pointed out, there's an ongoing investigation. Social media, as you said, people were advertising their bad acts. The gentleman showing the blood on his hand from the woman who was shot in the neck trying to get through a glass window. So this investigation is far from over, and I think the charges will get worse for some of these people. And I think it's also going to start to paint a picture of where that mayhem was organized, where it was planned, how it was executed. And that is where you're going to find out and get the answers to the question you just asked. Who's behind this? Is this a concerted effort by a number of organized groups and domestic terrorists?
A massive breakdown in intelligence as well as policing. Those who did the job, congratulations. They fought off immeasurable odds because the right thing wasn't done beforehand. We got National Guard troops that are now stationed inside the Capitol of the United States of America as a result of this. And I know those on the fringe groups and on the far right are cheering it, but I expect, as Bob is indicating, an overwhelming response by law enforcement with regard to not only prosecuting, but deterring future acts like this as well. So sad, so unfortunate. We're going to have to take a quick break here, but when we come back on the other end, Ahmaud Arbery is back in the news. We'll be right back.
Was he defending himself? Did it
Yeah.
look like he was defending himself to you?
Yeah. I mean, if the guy would have stopped, you know, I mean, find out what was going on, he obviously was up to something. I mean, this would have never happened. You know, should we have been chasing him? I don't know. You know, I mean, but yeah, no. At that point, one time when I cornered him up over here, he was trying to get my truck. He tried to get in my door.
Okay.
So
That was on his road here?
no, it was on that road.
On that road. So
Yeah.
he came up to your door and was pulling on your door handle on the driver's side?
Matter of fact, he's probably
So let me ask you this. What did it look like he was trying to do? He was trying to get on this side of the car, right? What did it look like he was trying to do? What
I mean, I'd cut him off pretty good now, you
Okay.
know. But I mean,
did he actually pull
was
on your
trying-
handle?
I wouldn't be surprised if that's his marks right there.
Okay.
He was trying to get to the handle.
Okay.
Yeah.
All right. All right. Did nobody got this on video? You just witnessed it,
Yeah,
correct?
I got it.
You got it on video?
I ain't looked at it.
Okay.
You ready?
Yes, sir. Yeah. At what point did you start videoing?
Well, I thought he was gonna get away.
Okay.
So that was
So
the
you
reason.
was trying to get capture who he looked like?
Yeah, I mean, to be honest with you, I probably got 2 videos, 3 videos. I mean, it probably
Okay.
started over here. I don't know what I got because half
Okay.
the time I was trying to drive. Then I realized I ain't my damn seatbelt on. So I get thrown
Okay.
through the damn windshield trying to chase this joker.
Okay.
You know, so I kind of threw the phone down so they ain't gonna tell them what's on there, to be honest with you.
Okay.
But I think this is on there
Okay.
because at this point I could see his face with my camera.
Okay.
And because he had turned back around coming this way, so that's the reason I picked the phone back up the video at that point.
All right. Yeah. Let's take a look, man.
Okay, so that's William Roddy Bryan Jr. You've seen that tape probably a number of times. You're following this case. He has a new application made to the court. Now, he was the individual that was behind the father and son team as the altercation occurred, and he was videotaping the incident. Well, he is now saying through his attorney that he has seen the prison cardiologist and that he is on meds and he's being treated, but his blood pressure is still 180 over 100 plus at any given time, and that he's not able to meaningfully participate. And they're asking in his defense, and they're asking for a compassionate release from prison while he is waiting for trial. As you know, all 3 defendants have been denied bail in the case. Bob, let me go to you first. Now, that blood pressure of 180 over 110, when it's being controlled by meds, is extremely high. It's very high in the jail. In my estimation, with all due respect, and I don't know this particular jail, but I've been around the block for 30 years doing this. I've prosecuted cases in which people didn't get the right health care. I've defended cases in which they didn't get the proper health care. A number of people that I've been involved with in the criminal justice system have died because of the neglect of health care. Now, keeping in mind that he's presumed innocent, and of the 3, and it's going to be, people get agitated. Of the 3, he is the least culpable of all 3 individuals. I don't believe he's got a prior record. There's no instances of failure to appear in court that I am aware of. And those are traditionally the factors that courts look at in order to assure the presence of the defendant at trial. I mean, not having proper medical care should not result in a death sentence. And I know that may sound odd as a prosecutor who's very hardcore on criminals, but if they can't maintain and control it, they either control it or, in my mind, the judge has to make the tough call. What do you think?
Well, I think a couple things. Number one, you're right. First Amendment's implicated here. Not the First Amendment. Presumption of innocence is implicated here. So, you know, we're in an issue where now the due process gets employed, and part of that is going to be that he's able to fairly defend himself, and if he's medically in a bad position, he may not be able to do that. So those are facts. The other point you made is that all these cases are really unique. So you have to look at the facts, and the first fact is, number one, you know, justice's interest in this case is to make sure that he appears for trial, that he's not a threat to the community, and that he was not a threat to the process in terms of witnesses or tampering evidence or anything like that. So presumably those were there, and right. If there was bail set, I'm not sure what the bail circumstances were here. So he could have been out on that. Assuming that he couldn't get out on that, now you have the compassionate release, and that's where you get this due process and presumption of innocence considerations as well. You know, so again, it's going to depend on whether he can get the adequate care there. If he can't, then the judge has to look at.
What do you think, Michelle? You're a former prosecutor, and you've handled lots of felony cases. I'm interested in your perspective from a prosecutorial standpoint.
So I think this is a little bit different because we're talking almost about a bail argument versus somebody who's been in prison for a long time, who's asking for humanitarian release, which is a granted in rare circumstances and usually for a terminal illness. So because this is dealing with bail and somebody who they're just trying to get back to court, I think if he makes a strong case that his life is in danger, he's got a shot. I have dealt with cases where defendants have been released. We had one where he was on dialysis on a nonviolent felony and he was released. So, I mean, yes, you're right. This shouldn't be a death sentence to him. He wants to stand trial. He wants to be able to participate. I will make note that this is the second time they've tried to use another reason to get out. The first time, I believe his defense attorney said that he was just the cameraman and he wasn't really involved and just a concerned citizen. So I think they're really going to have to make a strong argument for his case that he can't get the proper medical treatment, but he might have a shot.
Okay, great. You know, Ahmaud's mother has been very vocal about this case, and it's heartbreaking. Let's take a listen to what she's had to say so far about what's been going on, about the death of her son, which is being alleged to have been a murder.
As the court may imagine, I have suffered. I continue to suffer mentally and emotionally while I wait for justice for my son. My daughter, Jasmine's older sister, Jasmine Ahmaud's older sister, his best friend, just had her first baby. I often think as she begins the journey of motherhood, will I have the words of wisdom to help her along the way? Mothers protect their children. I wasn't given the opportunity to protect my son. I'm here to ask this court to help me be a mother who protects my grandchildren and fight for justice for my son. He ran this path many times, and our home was just a light jog away. But for him, no matter how he maneuvered, no matter how fast he ran, no matter how fast he ran, or how quickly he turned, these men refused to let him go home. They should not go home now to prepare for their defense, to enjoy their children and grandchildren, and to be embraced by the community. These men are as dangerous today as they were on February the 23rd of 2020.
Michelle, you know, as a prosecutor that I'd be interested in your feelings. Like, I always like trying cases against really skilled defense lawyers because it just seemed you didn't have to deal with the crazy sometimes that you deal with lawyers that aren't. And you play a better game when you have an adversary that's worthy. These defense attorneys have filed motions such as to stop prosecutors from using the word victim in court because they say that is reversing the burden of proof because he can't be, the jury makes a decision as to whether he's a victim or not because they're claiming self-defense. They want to limit the amount of trial photos and autopsy photos to one And they don't want a person from the family to make those identifications. They want to forbid spectators from wearing masks that have things on it like Black Lives Matter, I Can't Breathe, or similar slogans. And they're looking for all of the medical records, criminal records, disciplinary records, mental health records, telephone records, and social media accounts, et cetera, if any, to be produced. That's a pretty significant array of motions. Something's telling me these lawyers the defense lawyers know what they're doing here.
Right. Well, I completely agree with you. You would rather go up against somebody who knows what they're doing. It ups your game. Although sometimes it is nice to have somebody who doesn't. But these motions are going to depend. You know, they're arguing that calling Ahmaud Arbery a victim is going to be more prejudicial to the jury than probative. That's an argument for the judge to determine, especially if it's self-defense. I don't know if it's going to work. He was shot while he was running in broad daylight, so that's going to go against that. And as you, Bob, mentioned, right now they are presumed innocent, the defendants, but that means the prosecutor, it's their burden to prove beyond a reasonable doubt, a very high criminal standard, that these three are guilty of the murder. So if they need, the prosecutors have to be armed with all of the material that they need to in order to meet their high burden. So I think the judge probably will give them leeway to use the materials that they need.
Right. And Bob, you know, a lot of people get in the lay community get agitated when they hear this, but the defense attorneys point out that First Amendment rights, if you want to do that outside, if you want to call them a victim outside, if you want to wear those masks and shirts and so on and so forth, fine. But when you breach that line and come into a courtroom, it's about fairness and the defendant getting his Sixth Amendment rights and all of his other constitutional rights to a fair trial. And so that's why these motions are being filed. So whether the judge grants them or not, the defense does have a fair argument to say that we want to mitigate any prejudice and let it be more about the facts and law as opposed to the court of public opinion, which is more and more over the years, Bob, you tell me in your experience, becoming more about trial by court of public opinion as opposed to trial by law in a courtroom.
Well, the explosion of media on, in every facet of our life, it's really hard to get away from what's going on. So yeah, I mean, you're not going to be able to shield people from perhaps comments that shouldn't impact what they're going to be doing, for instance, if they're a juror in terms of deciding a case. So, with respect to the defense counsel's arguments, what they're saying is, look, we're not saying you can't have a First Amendment right to exercise how you feel about the process, how you feel about how that process is applied to certain communities. But what goes on in that courtroom, both from the defendant's standpoint as well as the public standpoint, is we need to maintain an integrity of a system. The Sixth Amendment says you have an impartial jury. You don't want to threaten, intimidate, or influence that jury in any way. And that is why the judges have a lot of leeway for what goes on in that courtroom, because the focus should be on allowing the parties to address what justice needs to do, and that's that the defendant committed a crime or didn't commit a crime, and that's the person that should be subjected to the process.
All right, guys. Ghislaine Maxwell, believe it or not, who has been denied bail twice, is back in the news. We're going to get to that on the other end of the break. Stay with us.
Today, after many years, Ghislaine Maxwell finally stands charged for her role in these crimes. These charges we announced today are the latest result of our investigation into Epstein and the people around him who facilitated his abuse of minor victims. That investigation remains ongoing. My office and the FBI remain committed to doing all within our ability to bring justice to individuals who enabled, facilitated, and participated in the acts of abuse. Combating the exploitation of children is a priority of our office. We are committed to pursuing and prosecuting those who exploit and abuse minors, in this case, in every case. And to that end, I want to say to anyone who is watching or hears about this prosecution, if you believe you are a victim of Jeffrey Epstein or Ghislaine Maxwell or anyone else who helped them, regardless of when it occurred, or have information about the conduct alleged in the indictment unsealed today, please let us know. You can reach the FBI and have access to victim and witness services by calling us at 1-800-CALL-FBI.
All right, Ghislaine Maxwell has 3 times a charm tried to file for bail to be released, 3 times denied, and now is appealing the latest denial. The prosecutors, of course, are saying pretrial detention is necessary because to reasonably assure the defendant's appearance that she has contacts to France, it doesn't have an extradition treaty, she's got a ton of money, she's facing extraordinarily serious charges in the federal government that could put her away for a lifetime as far as I can see, and that there's been deceptive conduct on her past, in her past. Michelle, the defense is saying here that this is de facto solitary confinement, that under the most severe circumstances, she's been excessively and invasively searched every day, monitored 24 hours a day, that there's camera surveillance in her cell, supplemental cameras follow her when she's allowed out of her cell just for short periods of time, and that she's woken up essentially every 15 minutes to see if she's still breathing when she's trying to sleep, and that she is basically completely isolated. Give me your prosecutor version as to what you're going to say as to why the prosecutors are correct that Ghislaine Maxwell is a threat and a danger and should not be released, as opposed, Michelle, to their suggestion that they'd have a guard watching her if she was released, GPS monitoring, and home confinement. Why isn't that enough?
Well, right. This is a huge break from her rich and famous lifestyle that she's been living her whole life. She is in jail for sex trafficking, so it's going to be a huge difference. But prosecutors are exactly right to want to keep her in. This woman has so much money. She's asking for almost $29 million worth of security, which goes exactly to the point that she has this much money to escape. She has 3 passports for the United States, the UK, and France. So she has all the means to flee. She has almost no ties to the community. She is charged with exceedingly serious charges of sex trafficking. So all of those go to the reason why she should be behind bars. Yes, she could get granted bail, but she has a huge flight risk, and that's the #1 thing in trying to keep somebody and assure them that they're going to come back to court.
Okay, well, we just listened to the prosecution's argument. Bob Hille, I'm throwing it on to you as a defense lawyer. What are you going to be arguing as to why she should be released to counter the great argument that Michelle just made?
Well, you're going to say that, look, #1, there's a presumption of innocence. So the defendant is entitled not to be subjected to the system or detention until there's been a finding of guilt. Against that, society has an interest in making sure justice is done for that defendant and holding them accountable if they committed a crime. And that is where you get into the factors of flight risk, danger to the public, threat to witnesses. Once this defendant poses no risks in any of those categories, then they're really entitled to bail under the 8th Amendment here, because we're dealing with federal court. I think the Southern District issued the indictment. So the argument is going to be that the amount of money here, rather than indicating she can just pay and disappear, is substantial enough to ensure her appearance and that there are no other factors. The other interesting thing with respect to her treatment in the jail is that they don't want a repeat of Jeffrey Epstein, which is really what this case is all about.
Right, absolutely. Guys, let's switch gears real quick. A major decision by the Supreme Court of the United States in a case that rocked New Orleans, and that was with regard to reversing a conviction for the killing of Will Smith, who was the victim of a shooting. He was a former player for the New Orleans Saints. Cardell Hayes basically was convicted, but this was like an altercation that occurred on the street where they were driving their vehicles. There was an accident. It's alleged that Will Smith had driven away from the accident. Cardell Hayes went in pursuit, got into an accident with Will Smith's car. They got out of the car. They were exchanging heated words. Will Smith's wife was part of this whole thing. And then eventually Will Smith retreated to his vehicle with his wife when Cardell Hayes fired a number of times, striking and killing Will Smith and injuring and wounding his wife. He went to trial and he was convicted by a 10-2 jury. That's right, 10-2, not 12, not a unanimous verdict. Well, the Supreme Court had issued a decision earlier in 2020 in the case of Ramos versus Louisiana that indicated that non-unanimous verdicts are not constitutional. And as a result of that decision, Cardell Hayes has been released. The case has been remanded back to the lower courts to make a determination as to whether prosecutors will continue to pursue Cardell, who was basically arguing that this was a situation of self-defense because Cardell argued, he said that he was going back into his car to get a gun. Bob, I mean, no brainer in terms of the decision of Ramos versus Louisiana, but there's been a lot of controversy about this Louisiana law. I think there was only one state that had it, that you can have a non-unanimous verdict. Many argue, and I believe rightly so, that this was part of the Jim Crow laws all the way back to 1898 in order to ensure that minorities who may serve on jurors' voices were quelched by a majority of white jurors. Anyway, it's been on the books forever. What are your thoughts about how the Supreme Court ruled both in the Ramos case and here?
Well, I think in this case, the Supreme Court, well, of course, they got it right from their own perspective, and it's their call. But the fact that only 2 states were in this situation where they had non-unanimous verdicts, Oregon and Louisiana, indicate that it was about time to overturn the Apodaca versus Oregon decision from 1972, which Ramos did last year. So, it's no surprise here that this conviction based on a 10-2 jury vote was running counter to now what the law of the land is, that the Sixth Amendment requires a unanimous jury for a conviction on, in this case, it was manslaughter and attempted manslaughter of the wife who was shot once.
So, Michelle, by the accounts, at least by the news, the jurors came out, excuse me, and indicated it was a compromise verdict and that they weren't even happy with that. And still, the question was, as they were waiting for deliberations to come through and get a verdict, was it murder, is it manslaughter, or would the stand your ground self-defense law apply and exonerate Cardell Hayes? So tell me from a prosecutor's point of view, he spent 5 years in jail so far. You had a jury that even with the 10-2 couldn't come up with a murder conviction, but only came up with manslaughter, which is significant. You got a 25-year sentence of which he spent 5 years in. What is the evaluation that you go through as to whether or not you're going to continue with prosecution, or at least in my mind, you tell me if you think differently, after all this time has gone by, witnesses' memories fade, trying a case twice is never great for prosecutors. You may go to the defense and say, let's make a deal.
I think you're exactly right. I think it's very hard often to retry a case, especially one that's about 6 years old at this point. Just like you mentioned, witnesses' memories fade. You rely on testimony that's already out there, so you have many impeachable lines and evidence. You have a bunch of things that have changed, and I think it is in their best interest to try to maybe strike a deal depending on how much is left on Cardell Hayes' sentence. The jury clearly split the baby a little bit between murder and decided that he was guilty of manslaughter, which is a less culpable mind state. So that would factor into it as well. So I think from this perspective, they do have an opportunity to revisit it, save everyone a trial, and maybe come to a different plea.
Excellent, guys. Great analysis. Guys, we're going to take a break right now, but on the other end of it, we're going to have a primer on the law in a case in which a prosecutor's office on the second time after a lot of public pressure refuses to indict a police officer in a police-related shooting fatality. We'll be back on the other end of the break.
In response to the request from Mr. Grant's family, in October of 2020, I assembled a team of highly experienced attorneys to conduct an exhaustive review of the facts and the evidence surrounding the events that led to and resulted in Oscar Grant's death. We then analyzed the statutes governing the law of murder, manslaughter, and any other crimes that could apply. We looked at applicable legal doctrine and case law, as each applies to the facts and the evidence. We took our time, had many meetings, and delved deeply into the legal analysis before coming up with the conclusion that I have now reached and am endeavoring to explain to Mr. Grant's family as well as to our community. The California Supreme Court rendered an opinion recently, in fact on December 17th of 2020, which is incorporated into our review and our decision. Today, I will be meeting with the Grant family and their supporters to explain our decision.
Okay, so this was with respect to the Oscar Grant case, and the incident was back in 2009. And I'm in possession of the report. For those of you who are really interested in this case, you should take a look at it because it really has an incredibly detailed, whether you agree with the decision or not, analysis of the law and what prosecutors do when they're looking at evaluating a case. Michelle, let's talk a little bit about what went on here. One of the facts was that unanticipated to the police officer that they're looking at now, Tony Perrone, another officer is the person who shot the victim in this case. And that Tony Perrone had no idea that he was going to shoot him, and there seemed to be any reason to know that he was going to shoot him. The family got 50,000 signatures demanding prosecution, which honestly bothers me because you shouldn't demand an investigation, fine. But like the Attorney General is saying, it has to be based on facts and it has to be based on law. Now, the other police officer went to trial on murder charges and was only convicted of manslaughter. Manslaughter is now barred by the statute of limitations in this case because so much time has gone by. But the prosecutor lays out the fact that they just did not have significant enough evidence to connect Officer Perrone with the activities of the other officer who shot and therefore did not aid and abet. He was just at the wrong place at the wrong time. And then she finally concludes, there's a very detailed legal analysis here, that she believed her ethical duties as a prosecutor are only to bring cases that she can prove beyond a reasonable doubt to 12 jurors based upon probable cause. What are your thoughts about how this all broke out? Right decision, wrong decision?
You know, I'm not the one investigating it, so I have to go off what the prosecutor is saying. And it is very difficult for people who are not involved in the internal process to understand sometimes how a crime that looks so vicious can go unpunished or uncharged. But here it seems like she's claiming that there just isn't enough evidence to go forward that he was a part of the entire the murder. So I think, based on what she's saying in her investigation, that's what I have to go off. But I do sympathize and empathize with the family and community because it is very hard to understand sometimes how something so heinous can go unpunished or uncharged.
Bob, Michelle makes an excellent point that I've been talking about on the Law&Crime Report and the network forever. There's a difference between the feelings, and they say very clearly that because, by the way, he had hit the victim in this case, and he had done some things that were not right. The fact of the matter is he died from gunshot wounds, not from those injuries. And it does become difficult for the public to make a distinction between the fact that still the police officer is considered a defendant, entitled to all the rights of a defendant, including the presumption of innocence, proof beyond a reasonable doubt, and qualitative evidence that points towards guilt of some crime. So there can be a lot of confusion with the public. They see something that's horrible and don't understand why it's not being prosecuted. What do you think?
Well, I think that's just it. There is a lot of confusion between indictment and conviction, and the level that you need to indict and the level that you need to prove guilt and convict. And you and I have discussed, the ethical dilemma that lawyers have and which the public doesn't see, because not in that law is the ethical obligation that a lawyer has not to make frivolous claims. And that does put a burden on a prosecutor to say, hey, look, I can do a great splash, I can indict a cabbage, okay, and find some way to get probable cause. But at the end of the day, I'm going to have to prove this case in a trial with a jury. And if I know that I don't have the evidence necessary to likely get a conviction, then there's an ethical really consideration there that should keep that prosecutor from proceeding with the case and being honest with the public about it, that they can't prove get that conviction.
As far as I see, murder would be the only thing to be charged with. The guy who shot the victim was not convicted after trial for murder, only manslaughter, and manslaughter is now time barred by the statute of limitations. Let's listen to a little bit more of the district attorney.
Here, former Officer Perrone cannot be charged with the crime of murder under a traditional theory of criminal liability because both prongs of murder are not met. Perrone did not commit the murder or the act that caused the death of Mr. Grant. Johannes Messerly pulled the trigger, and that act directly caused Mr. Grant's death.
Michelle, talk to us a little bit about what the DA is saying there and what you need to prove for a murder, and what separates that from what happened in this case where she's saying there is no tie-in to any plan or participation even in the thing that killed the victim.
Right. She's talking about the fact that Peroni wasn't aiding and abetting this officer in this. So that's a totally different, separate crime. You need an overt act. And clearly in this case, she's saying Peroni did not have that mental state and he wasn't acting as part of that. So that's sort of going to differentiate why the one officer was charged and Peroni was not. And those are distinctions that you have to make through the investigation and through the exact facts. You know, you have to parse out the video, you have to parse out the witness statements, you have to parse out exactly what's happened to ensure that you're charging the right people.
Yeah, and Bob, let's go to some of the other cases that we've seen where I personally have felt that the court of public opinion drove the prosecutor to charge in order to satiate the public. And again, no one is saying that these things, they said right here, his actions were inappropriate, but they don't rise to the level of criminal culpability for hitting him in the head inappropriately, which was not the cause of death. But the fact of the matter is, do we do a service by just saying, let's throw it up against the wall and let the person be tried? And if they're not convicted, then you have a big problem with respect to that. And Bob, lastly, what about this idea that signatures and petitions are now being a basis upon which people are demanding charges, not demanding an investigation, but demanding charges? I think we're headed down a bad path with that.
Well, I think the first thing is that there's got to be integrity in the process. So that's got to be preserved. And that goes from the stage of indictment all the way through conviction. Petition, people have a right to petition. They have a right to be heard on something. But again, the obligation, and it's a difficult job for the prosecutor to be able to stand ground against an overwhelming groundswell of support to indict and to prosecute, not necessarily convict. And then, of course, you know, the final issue with respect to that, with that overwhelming community is that, you know, at the end of the day, where the more heinous the shooter's conduct was, the less likely you're going to be able to show that this other person that was there wasn't just as surprised as everyone else was on the platform when this occurred.
Well, Michelle, when I was the county prosecutor, I always said, let's not let the tail wag the dog. We make the right decisions. And if we have to deal with what we have to deal with in the media, at least we can hold our head up high. Let me ask you the question that everyone asks. It's the chicken and egg question. Is it better to have elected district attorneys that are more tethered to the constituency that votes for them, or appointed ones by the governor where they have much more independence? We got a short period of time. I'm going to each ask you that question. Where do you stand on that, Michelle?
I'm going to go with elected. For the people, by the people.
Okay,
I would agree.
Oh
would
my
agree.
goodness! All right. Let me give the counter argument. When I got the term for 5 years after being appointed by the governor, I didn't have to worry about what people felt about my decisions. I was freer to do what I thought was right. And in these cases that you see around the country where these bad prosecutions of cops result in not guilty verdicts, I say is swayed by the court of public opinion. And that wasn't right. We got 30 seconds. Bob, can you give me anything, like a little bit? Like that's a good argument. Michelle, real quick.
Appointed prosecutors are going to have greater insulation against bending the public opinion.
How about you, Michelle? Quick.
I think one man should not be making all these decisions. You need a team, you need a community. I think, just like I said, for the people, by the people. I'm going to stand by it.
Okay, guys, thank you so much. We got to go. Stay tuned for our regularly scheduled program. You can find me at Bianchi ESQ.